to the KJ method. What I've decided to talk about today are these essential vocabulary words that I have deemed the KJ words. Now, everyone talks about the vocabulary and how important it is, and I agree with that too. But I have designated these words the KJ words because I feel that if students have a good understanding of these words, it will help them be able to answer questions that they may not be able to answer otherwise. You have to understand, on the real estate exam, sometimes you're going to be able to answer that question positively, or you have to answer that question negatively. In other words, it's definitely not that, it's definitely not that, it's definitely not that, this is what's left. And so I believe that if you get a really good understanding of these words, it will help you do that. Word number one, appurtenance. I'm sure you have heard of this one. An appurtenance is anything. It can be a right, it could be an improvement, but it is something that runs with the land. Now, more important than that, because that's the definition you hear all the time. But what I want you to understand is that an appurtenance is something that is going to be real property essentially, because it's something that has to be left every time we transfer the property. And so we've heard this word in many different instances. The biggest ones are easement, appurtenant. What does that mean? It means that that easement runs with the land. It has to stay there. How about certain rights with the property? How about the pool? How about the fence? Those are improvements, right? So anytime you hear that word appurtenance, it means something that has to run with the land. But more importantly, if you see it in a test question, I want you to think something that is real property. Now, that's not exactly correct, but yes, it is something that has to be left with that property or will stay with that property for each successive transfer. Next word would be actual and constructive. Two sets of words, actual and constructive. What I say to my students is this: actual in the law is like the real deal. Constructive is like, we gotta make something up. Let me give you some examples to really hammer that point home. You hear the word actual being used when we know something happened. We have things such as actual agency. That means those people meant to create an agency. But then we have constructive. Constructive is not that we know it happened for sure. We don't know it happened, but we are going to presume it happened. We're going to assume some things. So, for example, you say actual notice. What is actual notice? That means notice we know you got. Somebody told you, you heard it, you read it. But then we hear this term constructive notice. Well, what does that mean? It's not notice that we know you have, but it's notice that we know you could have gotten if you would have just gotten off your tookish and done what you had to do. And so, for example, if someone records a deed, you should know they recorded the deed if you would have just got up and went to look. We see this again when we talk about evictions. What is actual eviction? That means the landlord is kicking you out. But then what is constructive eviction? It is the tenant saying, hey landlord, it's like you're kicking me out. You letting the roaches run around here? You were letting the roof leak? It's like you're kicking me out. So you're not actually kicking me out, but it is like you're kicking me out. So understand that most of the time, particularly when we're talking about notice, we don't require actual notice. We only require that there was constructive notice, which is something less than actual. And so what I say to my students is actual is the real deal. Constructive is like we're making something up. Well, we also have these words called express or implied. There we go again. What does that mean? Express means that the people expressly said it or did it or meant to enter into it. It was clear what they wanted. So we call it an express contract, for example. And what we're saying there is that the people intentionally entered into that contract. They meant to enter into that contract. But then we have this word implied. Implied means we got to make something up. Let's look at their actions. Let's see how they're acting. Let's see if it makes sense in that situation. So, for example, we heard of implied right of access, implied agency. Well, what is the court doing in those situations? The court is making something up. They're saying, hey, in an implied right of access, you paid for an easement. You probably should be able to get to the easement. And so what comes with you paying for the easement is the right to get to the easement. How about an implied agency? We're saying, hey, you're acting like the person's agent. You're leading them to believe you're their agent. And so the court is going to say, you were their agent. Now understand, when we utilize the terms express or implied, the court is never going to imply anything if the people expressed something different. And so if it's clear what the people want, then we will not have anything done by implication because we don't need to, because it's already clear what the people want. The next term I like to talk about is called accession. Accession. We see this term when we have a trade fixture situation. We also see this term when we are looking at changes in title for wind and water kind of conditions, right? So the term accession simply means someone is acquiring title. And so if you look at it from the perspective of a trade fixture, what do we say? If you don't take that trade fixture, by the time the lease is over, the landlord is going to acquire the title by accession. The same thing if you were in a situation with changes of title with wind and water. If you had a situation where there was accretion, well, the owner acquires the title to that new land by accession. The next one we're going to talk about, alienate. Alienate. That is a very important word. Alienate simply means that the title has been transferred. Now, be careful. It doesn't say how the title has been transferred. It doesn't say if the title has been transferred by sale or by gift. It doesn't say, but it simply says that title has been transferred. And so that's an important word for you to know that. And then also when you get into mortgages, when we talk about alienation clauses, what does that mean? It means the bank doesn't want you to transfer the title unless you pay it off first. The next one would be equitable. What does equitable mean in the law? It means fair. We have situations in the law where maybe it's not quite covered, but it's fair in those circumstances to allow this to occur. We look at things such as in land contracts, we have legal title and equitable title. Why is it equitable? Because this buyer is paying some money. So it's fair to let them have some interest in this property. We also have an equitable right of redemption. What does that mean? It means the person can redeem a property. But when is the most likely time that it should be equitable? Before anything really happens. So let's say, for example, you're going into foreclosure and you get that foreclosure notice, but they haven't actually foreclosed yet. So what do you get to do? You're going to run to Vegas, come back, you're going to say, I won, and you pay all the money to the bank. Does the bank have to take it? Yes, because it is equitable for you to pay that money before they have actually foreclosed on the property. So equitable means fair. The next two words, statutory and legal. Statutory and legal. These words mean that they have been created by law. We see a lot of statutory and legal words when we are talking about the state law. You understand that most of our testing is on the national level, but then there are certain states that test on the state level. Well, when they test on the state level, what we're saying is they created a statute, which is different from the national law. And so anytime you see statutory or legal, it means created by law. Now, why do we create laws? We don't just create laws out of anywhere. We say, something is a problem. There's a problem. And so let's create a law to make it not a problem. What kind of things do we look at? Mechanics liens. Mechanics liens is a statutory lien. It's one that wouldn't normally exist, but now because this vendor has improved someone's house, and since they've gone out there and they've improved someone's house, we're going to say, let's give them a special lien. You look at things like dower and courtesy. Those are statutory laws also. So anytime you see the word statutory or legal, understand that it's created by law. Very often statutory created by state law. State law. The next two words, general and limited. General and limited. We see this in general partnership. We see it in general agency. We see it in general warranty deed. So what does general mean? It means everything. Everything, right? General warranty deed. What does that do? It gives all the promises, right? General agency. It's a broad agency where you combine the person in the day-to-day. What about general partnership? Yeah, you're the partner that is involved in the day-to-day. So you got full liability in the partnership. But then we hear this word limited. So what does limited mean? And very often you hear limited or special. We use them interchangeably. Limited or special means it's going to limit the general in some way, shape, or fashion. And so when you see this word limited, at least look for the test answer that says something is being limited. And so if we have the general warranty deed that gives all 5 covenants, how does the limited warranty deed limit the general? We have general agency, and then we have special agency or limited agency. So that means that it's more limited than the general. The next word is operation of law. I love this set of words, operation of law. Operation of law is like a trigger, right? And so if you looked it up in the dictionary, it would say things that happen automatically in the law. What is that exactly? What it means is something happens which triggers something else to happen automatically. We don't have a lot of things that happen automatically in the law, but there are some things that happen by operation of law. Let's talk about them. If a person dies, immediately by operation of law, either the will kicks in or the laws of intestate succession kick in. If you have a fee simple determinable and you breach the condition, automatically it either reverts back or there is a remainder. If you're in a community property state and you decide to go ahead and get divorced, automatically at the point of divorce, half and half. Let's do one really good one. Joint tenancy with the right of survivorship. What happens when one of the joint tenants dies? Automatically, it goes to the other joint tenant. And that's why we say in a joint tenancy, you avoid probate. You don't have to worry about probate at all in a joint tenancy. Well, that's it. I wanted to go over those words with you. I call them the KJ words. I think that they are very important for understanding the real estate exam. So hopefully they were helpful to you also. Once again, go ahead and subscribe to our YouTube channel so that you can get notification on when we upload the next video. Thank you for joining us. See you next time.